Hi, I'm Cynthia Keel, and I'm here again today with my learners colleague, Lisa Monroe, and we're offering our perspectives as arbitration counsel and as arbitrator on a variety of topics. In episode 1, we talked about the benefits of arbitration, including choosing your own arbitrator. Today, in episode 2, we're going to talk about how to choose your arbitrator for your dispute. So last episode, we talked about all the benefits to be achieved of arbitration, and one of those key benefits was the ability to choose the arbitrator. And that's one of the most significant roles as arbitration counsel, because if your client comes in there and they want to be able to choose their judge, you don't want to provide them with advice that leads to them astray in terms of who ultimately adjudicates their dispute. And from my perspective as counsel, there's 4 main considerations on how to choose an arbitrator. The first is, what's the nature of the case? As lawyers, we generally think all arbitrators should be legally trained. That's our go-to. In that, we're looking at senior litigators like you, Lisa, or we're looking at retired judges. And there are numerous very qualified arbitrators out there who are legally trained. However, that may not be what you actually need in your dispute. You should examine the issues pretty carefully. If the issue is not a legal issue, but it's an issue that's about a particular engineering issue or evaluation issue, you might actually want an arbitrator who is subject matter trained. Somebody who may not have the legal training, but someone who actually understands this area and has a degree of expertise in this area. And so the first thing you really need to consider is, what's the nature of the case? What are the key issues in this case, and what are the attributes of the arbitrator and skill set of the arbitrator that I actually need in order to get to a decision that is done efficiently and with the correct speed, etc. And when you look at legally trained, you do have a number of arbitrator choices out there, and you should consider what the legal issues are, and you can do research on your arbitrator to find out whether they have expertise and knowledge in those areas, as well as deciding whether you want someone who is another lawyer or you want someone who is a retired judge. The second issue that you're going to consider is, what process are you looking to adopt? And you, again, in doing research, you will find out that some arbitrators can be more creative and flexible in process. Some are much more interventionist. Some are much more hands-off. And you'll have to figure out for your own perspective, and really thinking back from episode 1, all the benefits of arbitration, what is it you want to realize? Is this arbitrator going to help me realize those benefits for my client or not? The third thing to consider is time. Arbitrators and quality arbitrators are often quite busy. And if you've identified that speed is important to you, and if you're looking for that case management that you talked about, Lisa, in the first episode as being key to you, then you better choose an arbitrator who actually has the time to deliver on those, who has the time to case management and deal with the issues, and has also the time to deliver the award. And that's because a lot of times in arbitration clauses, there are requirements of when the award can be delivered. And so you need to be upfront in talking to your potential arbitrator about what the timing requirements are. The fourth consideration is, what's the quantum at issue here? Not every dispute is bet the company litigation, and therefore not every dispute needs the most expensive arbitrator, meaning the person with the highest fees associated. And sometimes as lawyers, we get in the trap of, if they charge the most, they must be the best. And that simply is not true. There's a lot of really good quality arbitrators out there who can do an arbitration over a small dispute in a cost-efficient manner. And if you need that, and your client needs that, you want to make sure your client's not detracted from doing arbitration because it becomes cost prohibitive, when one of the benefits that we talk about in arbitration is that it can actually be quite cost-efficient. So I think that's something that you need to have a pretty frank discussion with your client about. Keep your mind open about the quality of arbitrators out there who can do small arbitrations. And the last thing I want to talk about, which wasn't one of my 4 main considerations, but one of the things that I think we're increasingly talking about in our profession, is diversity. Our corporate clients don't want the same people being chosen time and again. They recognize that there's quality people who can do arbitrations that reflect the diverse nature of our profession and the diverse nature of their business. And we should be, as council, putting those people on the list of potential arbitrators, and recognizing that we don't allow our own unconscious biases to get in the way of doing that. So from my perspective, there's a lot of really good arbitrators out there. They bring different skill sets, and your job as council is to research them. And then come up with a list, recognizing that if you're choosing with other council one person, you may not get your first choice, but fortunately for everybody out there, there's lots of good choices.
The appointment process starts from my perspective as arbitrator in one of two ways. Firstly, the parties may agree on the appointment of me as arbitrator, or they may have me appointed for them, either through a court process or by an arbitral institution which is administering the arbitration. So, looking at the first scenario, the parties are reaching out with a view to potentially agreeing upon me as their appointee. The information that I request at the very beginning is names of all the council, names of the parties, and that's to make sure that I don't have a relationship with any of them that could prohibit me from being independent and impartial, and more on that in a moment. I also ask to see the arbitration agreement because it's important for me to understand if the parties have agreed on a particular process or if there are timelines that they've got in their arbitration clause that, for example, require an award to be rendered in a very short period of time. I need to know that so that I know I have the time to devote to it. The most important issue of all is maintaining my independence and our impartiality all the way through. And independence refers to relationships. That is, whether there is any relationship among a party or council which could potentially affect the conclusion that I might draw as arbitrator. And impartiality has to do with whether I have a particular bias in favor of an issue. And so it's critical that the arbitrator maintain both independence and our impartiality all the way through. And that starts with a conflict search, which is why I want to know the names of all the various people who are involved. But it also means that an ongoing obligation. So as witnesses, for example, are called, if it turns out there's a witness with whom I have a relationship, went to high school with that person, that sort of thing, those issues need to be disclosed. And the importance of that cannot be overemphasized, because failing in your duty of independence and impartiality can result in having your award challenged or set aside, and can result in having you challenged and removed from the arbitration. So that is absolutely critical. The next step is often an interview, and not surprisingly, parties who are considering retaining you and appointing you as arbitrator want to know a little bit about you and may want to interview you. And there are very clear rules about what is appropriate for an interview and what isn't, again, to ensure that you don't put in jeopardy that sense of independence and impartiality. There's a great little resource that you can get on the web called the Chartered Institute Guide to Interviewing Potential Arbitrators, and it provides the do's and don'ts. It lets you know when it's appropriate to do an arbitration pre-appointment interview, who can be there, what topics you can cover, and I highly recommend that. The other really helpful resource, again on the web, is the IBA Rules of Conflict. And those set out examples of the kinds of circumstances which could put in jeopardy an arbitrator's impartiality and ones which definitely don't. And I guide myself in every case by those two key resources. So the next issue is, what if parties can't agree on the appointment of an arbitrator? And there are a few options. If the arbitration is being administered by an institution, the institution will often appoint the arbitrator, and there are a whole bunch of different ways of doing that. In many cases, parties do have some choice, because the arbitral institution, for example, will have a list of potential candidates, and parties can strike off people that they don't want to serve as arbitrators. And it's a process that ultimately leads to, usually, consent, but managed by the institution. And if that doesn't occur, the institution will appoint. And then there's appointment by the court. And that involves a party bringing an application to the court with a few arbitrator choices for the court to choose. And so the involvement of the arbitrator in that process is to provide a resume and to ensure and commit to sitting as arbitrator on the terms set out in the application, and committing your availability if the court appoints you. And so that rarely occurs because, as you can imagine, parties don't really want a court to make decisions for them. As you've said earlier in our last session, one of the real benefits of arbitration is the ability to choose your decision maker. And as soon as that choice is being made by a court, you lose that benefit. So it's rare, but if parties cannot choose, that's available, and it means that the arbitration can get going, because sometimes the failure to agree on an arbitrator is a real stumbling block and a delay in getting the arbitration process going. One of the best ways to prevent delay, once appointed, is at the first procedural meeting. And we're going to be talking in the next episode about the importance of the first procedural meeting. What is it, and how it can help the parties achieve the benefits that you and I have talked about they want to achieve in arbitration.